Perfect. So we are officially live on Zoom. We're officially live on YouTube, and it's 5:01, which means it's after hours. So welcome to everyone, either watching via Zoom or via YouTube. Myself and Natalie are extremely excited for you all to be here. We have a really exciting topic today. As you can see from the screen, it is want to keep the house in the divorce. Try this. So Natalie and I are definitely going to do our best to uh, tell you what to do in an effort to keep the home.
Thanks so much, Joseph. I appreciate the introduction.
Of course. So, for everyone viewing, welcome to Family Law Now After Hours. Just please note that the purpose of this series is to discuss general information on separation, divorce, and other family law matters, and any information provided here should not be construed as legal advice. For those joining us via Zoom, we do have the Q&A feature, and that will allow you to submit your comments or questions throughout the presentation, and we'll definitely do our best to try to get to them. Unfortunately, if you are watching us via YouTube, you will not have the ability to provide questions and answers. That only, or sorry, the Q&A feature, I should say, that only is applicable to those viewing on Zoom today. And as always, if you have any questions regarding your specific matter, please call our office or a lawyer in your area to book a consultation to be able to receive tailored advice. And as always, stay tuned until the end as we will be sharing how you can schedule a free initial consultation with one of our lawyers here at Russell Alexander. Now, to introduce our two amazing hosts. I'm going to say two amazing hosts because that's what we are. We're definitely amazing, not to toot our horn, but we have Natalie here. Natalie was called to the bar of Ontario in 2006, and she provides clients with a peace of mind through sound legal advice and helps them navigate separations confidently. Focusing on dispute resolution processes such as collaboration, mediation, and negotiation, she aims to save clients money and achieve reasonable settlements. Specializing in supporting vulnerable clients, particularly those affected by family violence, Natalie offers legal knowledge, safety measures, and therapeutic resources. A certified collaborative practitioner since 2011, she serves on the board of directors for Collaborative Divorce Toronto and chairs its membership committee. She also serves on the board of directors for the Family Dispute Resolution Institute of Ontario, which is known as FDRIO, and she also co-chairs the Family Violence section. Myself, I'm a compassionate family lawyer driven by a deep desire to support families through challenging times. With a background in commerce, I bring strong negotiation, analytical, and critical thinking skills to my legal practice. And during my articling period, I've gained confidence in handling a wide range of family law matters. I emphasize active listening, clear communication, and empathy, fostering a comfortable environment for clients. I am as well certified as a collaborative lawyer with the Ontario Association of Collaborative Professionals, and thus I too offer clients an alternative dispute resolution approach to avoid court. Outside of work, I am a dedicated Toronto Maple Leafs fans. So, they could do well in the playoffs this year. I'm looking forward to it. We have 14 games left, and they play against Philadelphia tonight. Very exciting. As
There's
well as
always hope.
there's always hope, but let's see if they win tonight. As well as an LA Rams fan, and I enjoy playing hockey and watching comedy movies. And with that, that is our introduction for today. And I'm just excited to get started. We have such a great topic today. So many great um, factors that we consider when advising clients, uh, if it's really their intention to want to keep the home. And more often than not, clients do wish to go through that process, or at least they think they want to go through that process. However, they don't really necessarily understand the full scope or ramifications for doing so. So hopefully we can provide um, some insight today.
Well
So
put, my friend.
exactly. So firstly, I think before we even jump into um, what factors even come into play, I think it's really important first to at least understand the property division regime here in Ontario. And Ontario's Family Law Act, it's Ontario legislation, so it's provincial legislation, it's not federal legislation. Ontario follows the system or the process of equalization of net family property. And that's done whether that be through a separation um, or, in any case, leading up to the events of a divorce. But primarily, we look at what happens at separation. And for married spouses, there is what's called equalization of net family property. And married spouses through this legislation, sharing the growth of assets acquired during the marriage. But that doesn't necessarily mean they split each asset 50-50 down the middle. And what's really great about law in general is that there is always certain caveats that come into play. And the matrimonial home is one of those caveats. It's really, really unique in that the matrimonial home itself does not get deducted in property calculations, even if one spouse owned it before marriage. And um, we have lots of information from previous webinars as well as other blogs that we've posted to our website as well as on YouTube, Family LLB, where we discuss the Family Law Act and the property division basics in more depth. And we also have videos as it relates to the matrimonial home. So we've discussed that in previous webinars. But the main question I have for clients, or clients have for me, I should say, is they often ask, what happens to the house after separation? So there is usually about 3 or 4 factors or alternatives I tell clients that they have um, available to them. The first being that they choose to sell the home and divide the proceeds. So often the best financial option, and this is especially in the case if neither spouse can afford the home alone, uh, this is usually the process that occurs. And the proceeds are split after debts such as mortgages or HELOCs are paid off. And the market conditions and real estate trends normally dictate when the parties choose to sell. I mean, it's not entirely the case, but um, if the home does need to be sold so parties can get their equity out quick for whatever reason, sometimes the market conditions aren't necessarily respected. However, they do come into play. The other option that is provided to clients or in a general framework for negotiation purposes is that one spouse buys the other out. And more often than not, if the parties cannot um, determine collectively the value of the home, what happens is that it usually requires the joint retention of an independent home appraisal to determine the market value. And that's usually done through an appraiser through the CRA or the AAIC. More often than not, an appraiser with the CRA is enough, is they're more than qualified. However, sometimes for um, more complex properties, especially if we're deviating away from the matrimonial home itself, if we're dealing with other rental properties, or, um, for example, residential properties that contain 4 or 5 or more units, we tend to provide we tend to provide the AACI recommendation as the CRA appraiser would not be suited for that. But generally speaking, for the matrimonial home itself and acquiring its valuation, the CRA designation is more than suitable. And what happens when this occurs is that the buying spouse will typically refinance the mortgage and they'll pay the other spouse their share. So this means that the spouse buying out the other will solely be on title, and it'll be their obligation to refinance the home, of course, without the other spouse on the charge, and without having to be associated with any liability with respect to the home in general. And of course, it also may involve trading off other assets, which I'll speak to. Another option that I provide clients is what's known as a deferred sale. And that usually happens when there is an exclusive possession order in place, or, and more often than not, if a court orders exclusive possession. So what happens is that courts may grant one spouse um, often, it usually is the primary caregiver of the children, exclusive possession of the home for a set period of time. And there's various reasons in which exclusive possession would be ordered by a court, whether that be intimate partner violence, is usually the main characteristic. But the spouse staying in the home does not automatically get a larger share of the home's value. That's really important to understand. It just provides them possession of the home in the interim to create a safe environment for themselves and if there's children involved as well. And fourth and final option, and this is really less common, but it still is available. But in some cases, spouses can agree to temporarily keep joint ownership. And more often than not, that's as a result of child stability reasons. So if both parents are amicable, They're choosing to live separate and apart under the same roof. They may continue to keep the home jointly owned, especially the case if neither one of them can afford to seek alternative residential accommodations. And it's just simply not in their budget to do so, which we see, although it is less common, but it's definitely something we do see. Some key considerations, having all these options provided to my clients. The first one being, can you afford it, right? So the mortgage payments, property taxes, insurance, and maintenance really do add up quickly. And normally you're going from a dual income household now to a singular income household. Finances get tight, so it's really important to make that determination and speak with your mortgage broker on whether you can afford it. Also, another factor and a consideration I advise clients before making this determination is how will it impact the children, right? So stability is super, super important, but at the same time, financial security is equally important. And thirdly, the legal obligations. So the house itself cannot be sold or mortgaged without both spouses' consent, unless a court orders otherwise. So it's really important to make sure that both spouses are on the same page when determining how the home is going to be if it is going to be transferred or if it's going to be listed on the market. So, Natalie, now that we've sort of discussed the property division aspect, I know I touched on it briefly already, but can you maybe expand more on the concept of determining whether or not a person can actually afford to keep the home?
Absolutely. Thanks. You may want to reach out to a mortgage broker, as Joseph said, or a lender to see if you can qualify for mortgage financing or for a home equity line of credit. These are two lending options that may be available to you that could enable you to afford to purchase your spouse's interest in the home. If you have capital that you can use to purchase the home, that may be another option. So you may want to speak to your investment advisor about whether or not you can free up some cash in order to buy out your spouse's interest. Some clients elect to reach out to family or friends to see if they can borrow monies in a private arrangement if they're not able to qualify for commercial financing or financing through a financial institution. And you may ultimately end up saving money on interest payments that you would normally have to pay on a mortgage or a HELOC if you are able to secure one of those other funding options. If you do obtain a pre-approval for financing or you verify that you have the funds to purchase your spouse's interest in the home, you still may want to consult with a financial planner or an investment advisor to see if you can generate sufficient income to pay for all of the carrying expenses of the home on an ongoing basis. It's helpful to have that professional assist you with creating a budget so that you can see on a month-to-month basis where your money is going and whether you can potentially cut any expenses that are wants and not true needs. This can help you to manage your spending moving forward. It ensures that you prepare not only for those regular monthly payments, but also for unforeseen expenses that might arise. For example, repairs and maintenance of the home, or ongoing legal fees or litigation costs or expert fees, for example, which you may not want to incur, but which may sadly come down the pipeline. Anything you'd like to add to that, Joseph?
No, I think it's great. I mean, you know, people often think that they have more capital available to them than what they really do. And more often than not, on a preliminary look of their finances, they may think that they do actually have the funds necessary to proceed with a spousal buyout. But in reality, when they look at what a sole or individual household income actually looks like, and given the interest rates and the difficulty in actually securing mortgages based on sole household income, it does become very difficult at that point. So really reaching out to financial specialists, as you said, I know us lawyers, we do wear multiple hats, and more often than not, we do wear the financial professional hat. But I mean, it's really important to seek tailored advice from a professional who actually specializes in that field. Lawyers deal with the law, right? We are knowledgeable in some aspects of relation to finances, but like as Natalie said, it's really important to seek out the mortgage broker, really important to seek out the financial professional, your accountant, whether or not this is a viable option for you. We do have a couple questions rolling in from the Q&A section. There is one that I think would be really good to address. However, I think I'm going to do so after I discuss our next topic, which is negotiating a fair trade-off, offering other assets in exchange for the house. So what exactly does that mean? Well, to look at the equalization process itself and to, provide an example or at least an explanation to our viewers on how assets are divided. It's important to note that each spouse, through this process, calculates their total assets minus their debts from the date of marriage, and on separation. And this creates what's known as net family property. And I often explain net family property to clients as it being synonymous with your net worth. So how does one person calculate their net worth? They take their assets minus their debts. So very similar in the family law realm. And the spouse with a higher net family property, which is the net worth increase during the marriage, pays half the difference to the other spouse. So instead of a direct buyout, a spouse may offset the value of the home with other assets. And that's something we see very common. The first being a pension or an RRSP. So keeping the home may mean forfeiting a share of the other spouse's retirement savings. That's something that we do see. Another option we see is the the offsetting of the value of the home with other investments and stocks. So they may be liquidated for a settlement. So sometimes, and maybe not quite recommended, as always, us lawyers provide the law as it pertains to your actions, but not necessarily whether or not they're financially smart. And that's why we always state to seek financial professionals' assistance when making these determinations. But more often than not, some people do liquidate investments such as a TFSA or stocks in order to offset the value of the home. Sometimes, if the parties have multiple properties, they'll use other real estate as a means to offset the value. So sometimes they look at rental properties if they're available to them, or vacation homes as a means of a trade-off if they want to keep the matrimonial home. And other assets that are sometimes used are vehicles, or more often than not, business assets. So if one party or a spouse does have a business, they may forego or liquidate business assets as a means to offset the value of the home. Um, as always, there's always these important characteristics, or not characteristics, I should say, considerations before trading assets for the home. Again, we're lawyers, but we do speak to, I would say, three main considerations or factors. The first being liquidity, right? A home is not a liquid asset. Cash or investments may be a better trade-off, and that's something that we tend to inform our clients. The second being the market risks, right? So the real estate market fluctuates. Home values can rise or fall after settlement. That's also really important to note because more often than not, people think that um, you know, they're locking in a home value, um, and more often than not, that's not the case, right? The real estate market fluctuates. There's risk associated with that. And the value of a home in January of 2025 can be marginally different than the value of that same home in August. We've seen it during COVID. The market changes rapidly. So that's really something to consider. And the third being long-term financial security. So, after you're discussing whether or not you want to liquidate your entire TFSA or you want to liquidate your RRSP, um, the question remains, will you be left with enough cash flow for future needs? Again, that's not something a lawyer can advise you on. More often than not, we will direct you to a financial professional. But these are definitely important considerations that need to be taken into consideration. And with that, Natalie, maybe I can ask you this question. This is one of the questions we've received from our Q&A feature. And someone asks, what if only one spouse is on title? Will this affect how the proceeds are split?
Essentially, is my answer because, as Joseph already canvassed, there may be an equalization payment that's owing between married spouses. And there could be other heads of relief or claims that are made as well that also need to be paid from the net proceeds of sale. So typically, what we see is that when the home is sold, the net proceeds of sale will be held in trust until we can resolve the issues on a final basis. Sometimes spouses can agree to have a temporary partial release as an advance prior to the conclusion of their matter. But yes, in short, the way that title is carried may impact ultimately how the proceeds are divided alongside all of the other outstanding issues and claims.
For sure. And I mean, more often than not, the files that we get, the home tends to be the largest asset that we're dealing with. Either the matrimonial home if it's not being rented and it's owned, or at least there's some equity involved, as well as a pension. So again, as you perfectly explained it, that's how the proceeds of the home are split. But with respects to whether or not either one spouse or both spouses are on title, that doesn't take away from, again, one spouse's ability to unilaterally make decisions on how the home is disposed. If there is only one spouse on title, um, they do have um, they do have the let me rephrase. If there is one spouse on title, they don't necessarily have to agree to a spousal buyout, and they can choose themselves to list the property, and that those rights are afforded to them under the Partition and Sale Act. If there are two spouses on title, both spouses can have the obligation or power to force the sale of the home. So because they're both on title, they both have the ability to dispense with the property as they see fit. So, a spousal buyout is not something that a court can order. Rather, if there are
Unless
two,
it's on consent.
exactly, unless it's on
Yeah.
consent. But if both spouses are on title of the home, either one of them does have the power under the partition and sale legislation to force the home to be sold. So with that, let's move on to everyone's fun topic to discuss is mortgages and mortgage eligibility. So I know Nat, you spoke about it, previously already, but being able to more often than not secure the spousal buyout is through being able to solely refinance the home. So how do we go about that?
So I'll start off by saying it's prudent not to make any offer to purchase the home or enter into an agreement to buy out a spouse's interest in the home until you have that pre-approval for financing in hand. It's important that you have a trusted advisor verify that all of the preconditions for financing are met before entering into either an agreement to purchase or making an offer to settle in that regard. And why do I say that? Because you don't want to be stuck or on the hook owing money to your spouse if you don't actually qualify to get that loan or that financing to buy them out. Banks and lenders will typically request a copy of your signed separation agreement or your final court order to verify the extent of your cash flow on an ongoing basis once you've concluded your matter before pre-approving you for financing. It's because they want to know what are your obligations with respect to support or what are your entitlements with respect to support, as well as any property division or equalization payments that may be owed or other heads of relief as I previously addressed. Ensure that you speak to your lawyer first to understand how the outstanding issues in your particular matter may delay or impact your ability to make an offer to purchase the home. It may be that child or spousal support payments are higher or lower than what you anticipate, and therefore it's important that the mortgage broker is provided with full and accurate information about what the settlement terms or the ordered terms are before you can potentially expect to receive a pre-approval. These payments help or hinder your eligibility for financing. Likewise, if you're found to owe an equalization payment to your spouse, this may increase the overall amount that you need to borrow to resolve your family law matter as a whole, let alone just buy out their interest in the home. Your post-separation financial health and the distribution of family income are relevant factors in assessing whether you are ultimately a candidate for mortgage financing. Do you have anything to add to that, Joseph?
I do have questions sometimes with clients, and more often than not, do you see that if children are involved and they are considered a recipient or a payee of child support, is that considered or is that considered by mortgage brokers as income for the purposes of refinancing?
In my practice, I've seen that mortgage brokers typically will ask for verification as to what the child support amount is that's payable between the parents, and they will deem it as a benefit, so to speak, to the spouse who's applying for the pre-approval for financing. So it is, in a sense, treated as income for them. Mhm.
Perfect. And I mean, there's so many ways in which one spouse can at least try to attempt to get this mortgage financing. More often I see sometimes they'll get their parents to be co-signers. You don't have to necessarily solely be on title and solely be on the charge, but more often than not, many separation agreements will explicitly state that if the one spouse cannot refinance with the other spouse, then they'll have to refinance the mortgage entirely. So that way, you're removing the liability for the other spouse, who I mean, I understand they don't want to be liable for an asset that they don't have an interest in. So that makes total sense.
Very
Um,
true. And I would just add to that that
for sure.
I've also seen situations in which mortgage brokers can be pretty creative, or there may be other lenders other than the main financial institutions or banks that people typically go to that may provide options with more flexible frequency in terms of mortgage payments. Spreading out the payments in a way that enables you to actually afford the financing. So do check with a mortgage broker to verify that you've canvassed all those options.
100%. And speaking of canvassing again with financial professionals who tend to know a lot more than lawyers do in this regard. Um, it's really also important to consider the tax implications, whether or not one chooses to sell or keep the home. And dealing with the key tax considerations, the first being the capital gains tax, right? So, as many of you either or know, or maybe this is new information to you, but the matrimonial home is exempt from the capital gains tax if it was the primary residence for both spouses throughout ownership. And if one spouse keeps the home and later sells it, the future gains may be taxed if it's no longer their primary residence. So that's really something to keep in mind as well. The second being the land transfer tax. And if a spouse buys out the other as part of the settlement, the land transfer tax may be exempt. However, if the buyout occurs outside of the divorce settlement, there are case law and instances, especially with the CRA. The CRA is a different breed of different breed of collectors, and I mean they definitely interpret the law. They're not lawyers themselves, but they interpret the Tax Act very conservatively, and there are cases where if the spousal buyout occurs outside of the divorce settlement, then the land transfer tax may apply, but more often than not, within the confines of the separation agreement, it's explicitly clear that everything is being taken into consideration while the parties are engaging through this process. The third tax consideration to be mindful of is RRSP withdrawals and the tax consequences associated with that. So again, as I mentioned previously, a spouse can use RRSP funds to buy out the home. Um, However, it's really important to know that the withdrawals are taxable as income. So that's something you really need to keep in mind and speak to a tax professional on if this is the right financial move for you. Um, some alternatives, a spousal RRSP transfer. Sometimes this is also part of the settlement without immediate tax impact. So that's another thing to be mindful of. And finally, are the mortgage implications. So, as Nat explained it, if you are refinancing to buy out a spouse, the thing to be mindful of is that new mortgage terms and interest rates apply. So, ideally speaking, if you can't get the spouse to be withdrawn from your original charge, and the mortgage broker um, actually requires you to refinance, which is more often than not the case, the new mortgage terms and interest rates apply, right? So that's really important to be mindful of. And early mortgage break penalties can be costly. So again, as always, consult a financial advisor, see if this is something that makes financial sense, see if there's financial stability and whether or not engaging in this process is actually going to be detrimental, not just maybe in the short term, but in the long term as well. You have to consider these options. Um, Nat, we also do have another question that has popped up. Someone asked, how will a court view keeping the home while claiming hardship, i.e., unemployment, can't meet spousal support obligations? What would you say? Is this something that courts will consider in letting one spouse keep the home?
Well, I would start by saying child support is a priority. And so if you're electing to try to assert the argument that you can't afford child support as a result of keeping the home, I don't think that the court would view that as a successful argument. And so it can be problematic potentially, depending upon the claims that are at play in your matter.
Perfect. Well said. So
Thank you.
moving on to our next topic, um, I spoke about it very briefly, but I'm really hoping that you can expand on this. And it's the idea of the parties, if the buyout is on the table, um, the parties need to ascertain the current market value. So where do you direct clients when this is the case and this needs to be done?
So I will say in the most collaborative or truly amicable cases, people are sometimes able to simply agree upon a value between themselves based on their own knowledge of what houses are going for in their particular neighborhood, so long as it's not a customized or a very unique property. However, I would say for the most part, people tend to go to realtors first to obtain a free opinion of value. And then often, if each of them obtain a value or an opinion that is quite different from one another, they may either meet in the middle, average out, a figure that they can both agree upon, or alternatively, we do refer them to certified appraisers in order to obtain an appraisal. An appraisal holds the most weight in court. It's also a fairly low cost, and therefore it can be a fantastic tool in helping spouses come to an agreement if they are considering a buyout of one of the spouse's interests in the home.
I normally find that, and maybe this is your experience as well, but I normally find that the letters of opinion are more often than not pretty liberal in the sense that when you come to a realtor seeking their opinion on the value of a property, they tend to increase the value of the home in the hopes that you get them, oh, like this might be a good time to list. Maybe we'll list it through this specific realtor. And I normally find that appraisers, which as you mentioned, do carry more weight in terms of the litigation aspect, they're more conservative values. And so, I mean, do you normally find like you have a preference? I mean, I know you mentioned that you gear clients towards receiving a letter of opinion first, but are there more times where you suspect, hey, it might be best suited to get an appraisal done on the outset?
Yeah, Absolutely. I think that the appraisals are typically a far more detailed analysis. It's actually usually in a papered report. It's usually quite lengthy. It contains a lot of considerations that may not be readily visible to the naked eye, just by, observing the home from the front walk. Typically, it does involve a full viewing of all rooms of the home. It may even involve looking at whether shuttles of the home are in good working order. It may entail a comparative overview of other properties in the neighborhood. Typically, it does list other similar homes that have the same features, number of bedrooms, number of bathrooms, etc., and gives a fulsome analysis and comparative breakdown. So the appraisal is certainly my preferred way to go. But when people are short on money, or simply interested in coming to a very expeditious and cost-effective resolution, there's no harm in first canvassing realtors for an opinion, particularly where they are truly amicable and they're looking for a child-focused resolution.
For sure, makes sense. And I know we've spent a considerable amount of time discussing the financial aspects of the spousal buyout, but we haven't really considered or at least spoken about the emotional aspects and the emotional attachment and whether or not keeping the matrimonial home is the right choice from an emotional intelligence perspective. And more often than not, people choose to want, or at least have an interest of wanting to keep the matrimonial home, um, is mainly normally if children are involved. I often find that emotional ties to the home, um, as it relates to, oh, my daughter or my son grew up in this home since childhood. It's their family home. This is what they like. There's the desire for stability, right? There's the desire for continuity in familiar surroundings. More often than not, parents really like the school that their children are enrolled in, and they want to ensure that they remain in the catchment area. So that's also another reason. More often than not, other family members might be in the area who maybe have some sort of parental, um, like they assist with the day-to-day parental obligations. So maybe you have a parent or both parents work, and maybe you have grandparents who deal with the pickups and drop-offs of after school. So that there's so many reasons why people would want to keep the matrimonial home in place. Um, and one of them too, actually, and I often started to hear this quite frequently, is, and maybe it might not be explicitly said by clients, but it's definitely implied, is the fear of the unknown, right? Everyone always has a fear of the unknown and a reluctance to move. So that's something I definitely see quite often. And I mean, we've discussed the financial burdens associated with why maybe this might not be the best choice, right? We discussed, the high mortgage payments, taxes, maintenance can be overwhelming, whether or not it's financially viable for you. And again, as you previously mentioned, um, if the house is not affordable without spousal or child support, it definitely may not be sustainable. And as we've seen most recently, at least in the last couple of years, people were getting mortgages with lower interest rates and being able to afford greater valued properties. And then as the market sort of declined and interest rates went up, people were no longer able to make those monthly payments and people were defaulting. So again, it's really, really important to speak with a financial professional. You don't want to be defaulting on a home and risk losing the equity you've put into it. Um, and then aside from the financial burden we've discussed, there's also the emotional burdens and your emotional well-being in considering whether or not to keep the home. Sometimes staying in the matrimonial home can prolong emotional distress. I've noted that people sometimes they 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 look at the matrimonial home, and the longer they're in there, the longer they're in that emotional slump, and it reminds them of the turmoil and the stress and otherwise emotional volatility they've gone through throughout the separation process, and it just doesn't give good vibes. I know I hear that often, and from a Gen Z perspective, it doesn't give good vibes. And more often than not, I tell clients that moving can sometimes offer a fresh start and a new financial opportunity, right? Moving into a home that is more suitable to or geared towards a single income as opposed to, again, a dual income. Um, and sometimes it's easier to do than not. And there's oftentimes people live in neighborhoods where they have multiple different types of home opportunities or home prospects, whether that be condos or single dwellings or duplexes. I mean, there's a lot of great options in most areas that still provide the opportunity to be in the same neighborhood, and especially if children are involved, to keep them in the same school catchment area. Um, and I also like to provide clients with alternative options. So again, selling and downsizing for financial stability is extremely important. Sometimes I might offer that renting might be a more suitable financial pathway before purchasing a new home, and that really allows people to assess their future needs. Um, and also, and I would say primarily, is that co-parenting agreements that allow children to stay in the same school district. So maybe if you allow your other spouse to actually take the home off your hands through a spousal buyout, this will ensure, even if you're unable to afford the spousal buyout, this will still allow your child to stay in the same school district, the same school catchment area. So these are also things that um, I like to put forward to clients for them to have, other perspectives, not just, oh, I want the home, this is what I want, and without considering other options. Anything to tag along on that one?
Absolutely. Yeah. I think it's good to be forward thinking in these situations and good to look at things rationally as opposed to emotionally. For people who are struggling with the emotional aspect of, leaving the home, I would suggest that therapeutic resources can be of great help. I'm a big fan of therapy. And for the reasons you stated, Joseph, like the memories tied to the home can often leave people in a bit of a frozen state, if I can put it that way, where they're not able to gain fresh perspective. So it's a good idea to consider whether or not having those memories triggered will keep you from making positive decisions moving forward. Downsizing may be more appropriate depending upon your personal circumstances. Regardless of whether you qualify for mortgage financing, there may be considerations that make downsizing appealing. For example, if it's expected that your child or your children will be leaving the nest soon to go off to college or university, or they're going to join the workforce within a short period of time, it may be that a smaller space is all you need, and therefore it is a viable or a good solution for you that will suit your needs. Where a person anticipates an increase in expenses in the future, it may also be important to look at other options. A decrease in income or other changes that are outside of your control, such as job loss or a contemplated job change, may also be a basis for looking at other forms of accommodation. And if you anticipate that you're going to have ongoing legal fees or there will be potentially indefinite ongoing costs of litigation, then you may also want to consider whether or not you can reasonably afford to juggle or balance all of those expenses alongside the carrying expenses of the home. A temporary lease or rental may help ease the financial burden in the interim and give the person the time they need to find their footing and plant roots. A realtor can help narrow down suitable accommodation options for you. And the post-separation lifestyle of the separated spouses may ultimately give them time to find their footing. So it's just a matter of figuring out where you're going to land in terms of your overall net income on a monthly basis before determining what you can afford moving forward. Hence why interim or temporary accommodations may be a good fit. Also, oh, sorry, I don't think we discussed it yet, Joseph, but one
Tell me.
option that we often suggest or recommend to clients in a collaborative context or in an alternative dispute resolution context is nesting.
Mhm.
And this is also a good temporary solution where the kids can stay put in the home while the parents alternate in and out during their parenting time. They're with the kids in the home. When it's not their parenting time, they're outside of the home, living elsewhere, staying perhaps with family or renting accommodations typically. And that enables them to use their time productively to feel out the parenting schedule and to ensure that they have a proper budget in place to afford whatever future purchase or lease that they're contemplating.
Amazing. Thank you. Yeah, and I totally nesting slipped my mind, so it's great that you added that in. Um, and when, clients come to us, albeit it is when they're going through a separation or they're contemplating a separation. Spousal buyout is a small fraction or a small piece of the puzzle that we deal with respect to the grand scheme of things, especially if there's children involved and dealing with other financial issues. There's a whole host and heap of issues that arise, when a party is contemplating or is actually actively engaged in the separation process. But regardless, the small piece of the pie does become a an important aspect in the sense that it needs to be considered, whether that be through a separation agreement, more often than not through a separation agreement. Um, and there's different ways in which a lawyer can actually provide legal guidance in that aspect. So lawyers ensure that all agreements, or I should say all domestic contracts, comply with the Ontario Family Law Act and that they are enforceable. And what's really great about lawyers and what we do is that we help identify potential pitfalls in agreements. So in the context of dealing with the home, the matrimonial home, and dealing with spousal buyouts, we see whether or not there are unclear buyout terms, whether there's future claims on the property that haven't been addressed. Sometimes we look at hidden tax consequences. So we look for all of these things if either A, we're presented with a separation agreement that's already been drafted by another lawyer and we're retained to provide independent legal advice, or B, sometimes, although we don't recommend it ever in the slightest, and we quite frankly frown upon it, but if parties themselves try to enter into what's known as a kitchen table agreement, where they themselves, without the assistance of lawyers, try to draft up their own separation agreement, which again, we don't recommend more often than not, and I would say way more than more often than not, they're not legally enforceable. So that's our role, and we ensure and basically identify potential pitfalls in any agreement that's presented to us. So with respects to a separation agreement itself, we make sure that, among other things, and again, we're just looking at the spousal buyout in this aspect. We make sure that the separation agreement clearly outlines who gets what, right? We look at the timelines for buyouts, and we also discuss or make sure it's noted what happens if payments are not made. So we make sure all of these terms are clearly and explicitly marked in separation agreements. If we're maybe not dealing with separation agreements and instead parties are engaged in alternative dispute resolution, whether that be mediation, arbitration, med-arb, collaborative practice, we make sure that this issue of the spousal buyout is something that is put forward and hopefully is addressed in these processes. And regardless, alternative dispute resolution can be faster and cheaper than litigation. However, if we are in litigation, and for example, there's a need for a court order, for example, for exclusive possession, in that sense that a spouse may need to stay in the home temporarily because there is a risk, maybe as it relates to intimate partner violence, for example, we help and we seek the court's assistance in providing relief in the realm of exclusive possession. So there's lots of ways in which a lawyer can can help. Primarily and ideally, we like doing things outside of court, whether that be through counsel to counsel negotiations that result in the negotiating terms for a separation agreement, in which, again, we clearly outline how the matrimonial home is dealt with, albeit if negotiations are not able to occur and the parties have to engage in alternative dispute resolution mechanisms, again, such as mediation arbitration combos, or collaborative practice. We make sure that each party's position on the point is addressed, and we work out ways to negotiate a suitable arrangement. So that's how lawyers can help. Um, and I guess lastly, Nat, maybe you can speak to, and I know this is something that often comes up in conversations, and I mean, sometimes clients don't necessarily want to hear, the truth or the practicality aspect of it. But how do you inform clients, or how do you self go through the process of explaining to clients being able to prioritize practicality over sentimentality when they're really saying, or they have a deep desire to keep the matrimonial home?
So it's a great question. I feel like what I tend to do is impress upon them that there are several competing interests at play, typically, at least theirs and their former spouses, if not the children involved, and sometimes others who are close to the family. And so, if they are able to step into the shoes of those other key players, they may be able to identify how keeping the home can impact all of those people, and also look at their own personal budget, have a fulsome picture of their own financial picture, develop a list of their short-term and long-term personal goals. To help them identify whether or not this is really a decision that's being made for good, sound reasons, that hopefully are in the best interests of their children, um, or if they're simply doing it because there is an emotional attachment and therefore there may be a bit of irrationality with respect to their decision. When they want to move forward quickly and they're hoping to resolve the matter in an expeditious way, often it's a good idea for them to take pause and reach out to those previous financial professionals that we referred to so that they can hopefully identify some of those pitfalls themselves about what they may come to face over time in terms of interest payments, while at the same time understanding they can't shirk their support obligations or the other payments that they may be found to owe to their former spouse. So that's a way that I would tie it back into our question in the Q&A that we had. You can't claim that it's important for you to maintain the home if it's basically at the fulsome sacrifice of all of the other key players who are going to be impacted by that decision. So yeah, ultimately, I would just suggest ensure that you discuss this decision with your counsel, as well as mortgage broker, so that hopefully you can get a good idea of all of the options available to you and understand what the ramifications will be down the road, no matter what decision you make.
Amazing. And I would say a great way to end this conversation today. We spoke about so many key points for consideration, whether it be the financial aspects, the emotional well-being aspects. And, with that said, do you have any final sort of thoughts to everyone watching either on YouTube or Zoom today?
Um, just that it was a pleasure speaking with you, Joseph. I really enjoyed this conversation, and I'm saddened that we're at the end of our hour, but I look forward to future events with you. This was fun.
Yeah, I know. This
Thank
was our
you.
first time together, and I mean, it's really great speaking to you. And Natalie is a seasoned lawyer, and she always has just so much to offer, and it's always great speaking to you because I'm a new call, and it's always great learning from someone who has so much experience. And um, even though I host these sessions, I still learn as we go through the sessions. Like, and hearing your perspective on certain aspects is really eye-opening. So I know that the audience today, um, if I learned something, then they had to have learned something, and I'm a lawyer. So, I mean, it's really great having you on the show. It was
Thank
amazing.
you.
And
Thank you so much. I just want to say, and you're so articulate, Joseph, and you're wise beyond your years. So that's what I love about our team is we're all highly collaborative and we all learn from each other. It's
no,
fantastic.
thank you. I appreciate it. And those on YouTube and on Zoom, thank you so much for tuning into Family Law Now. Following the session, a brief survey will appear if you are watching over Zoom today, allowing you to share your comments and suggestions for future topics that you'd like us to explore in the future. As always, your feedback is greatly, greatly appreciated. And you are actually able to book now to take advantage of this opportunity for a complimentary consultation with one of our lawyers here at Russell Alexander. In order to do so, please contact our intake team at intake, which is INTAKKE, at russellalexander.com. And please provide the code NY 2025. That's NY 2025 to schedule your appointment. You do have to schedule the appointment before end of day on Friday of this week. You don't necessarily have to have the consultation before that date, but you do need to make your intention known before that date. We do have another great event next week, and registration is now open. The title of next week's session is What Can We Learn from Celebrity Breakups? So that should be pretty interesting.
It sounds
All
juicy.
does sound juicy, doesn't it?
It
Um,
does.
I won't be there, unfortunately, but I know there'll be some great lawyers providing their insights. All you have to do is go to russellalexander.com/family law now, and you'll be able to register for next week's event. Again, thank you so much to our panelists. Natalie, thank you so much for sharing your insight today. And as always,
Thank you,
thank you, the
Joseph.
viewer, for thank you. And thank you, the viewer, for tuning into Family Law Now After Hours. It is now after hours, so we will let everyone go. And once again, thank you for tuning in, and thank you again, Natalie. You're amazing, and I think we should do this again. I'm down.
Let's do it. Absolutely.
Amazing.
Sign me up.
Perfect. Perfect. All right. Thank you, everyone. Have a great night.
Have a good night.